Welcome to this explainer. Look, right now there is a massive regulatory wave hurtling straight toward Australian businesses, and it's literally about to crash down in just a few days. We're talking about AML Tranche 2. This is a fundamental, ground-up change in how professionals operate across the country, and honestly, it represents one of the largest, most expensive compliance wake-up calls we've seen in recent history.
70,000. That's roughly the number of new Australian entities that are suddenly finding themselves right in the crosshairs of this massive regulatory expansion. We aren't just talking about giant multinational banks anymore, right? We're talking about everyday, local professional practices that have historically operated completely outside of this intense level of financial scrutiny.
Which brings us to the absolutely critical question, is your business caught in the net? If you're a busy accountant, a lawyer, a real estate agent, or a conveyancer, you really need to be paying close attention right now. The government is targeting these specific professions for a simple reason. You guys handle the transfer of significant wealth and facilitate major financial transactions for your clients. This isn't just some distant proposal being debated in Parliament anymore. This is law. And the July 1st deadline for full compliance is staring us right in the face. So, are you actually prepared?
Okay, let's dive into this. We're going to break down the AML Tranche 2 shakeup, exactly who is captured, your new legal obligations, those terrifying multi-million-dollar fines, a hidden insurance trap that almost everyone is completely missing, and finally, your action plan.
All right, starting with part 1, the AML Tranche 2 shakeup.
To actually survive this regulatory shift, we first need to understand the core of the problem. Like, what is actually motivating the government's sudden crackdown on your industry? Well, AML Tranche 2 is the expansion of Australia's anti-money laundering and counter-terrorism financing regime. It basically scoops up previously unregulated gatekeeper professions. So why now? The Financial Action Task Force, the FAF, which is essentially the global watchdog for financial crime, has been putting serious pressure on Australia. They've been pointing out for years that failing to regulate intermediaries, like accountants and lawyers, creates a gaping hole in the global financial crime framework. Malicious actors use legitimate professionals to mask dirty money. So this new law is the Australian government's way of finally closing those long-standing loopholes to meet international standards.
Moving on to part 2. Who exactly is captured here?
And this brilliantly illustrates exactly what we're dealing with. You might be sitting there thinking, hey, I just sell houses or I just do tax returns. But the government is now looking very closely at your daily operations to see if you provide what AUSTRAC calls designated services. Take a quick scan here. If you're a lawyer or conveyancer, things like property transfers, creating companies, and managing funds are captured. Now, legal professional privilege is protected, meaning your confidential legal advice stays confidential, but your administrative or transactional work? Caught. Accountants simply managing funds or executing transactions get you pulled in. Real estate and buyer's agents, you're captured for buying, selling, or transferring property. Even property developers selling house and land packages. And precious metals dealers doing transactions over 10 grand, you're on the hook. The main takeaway? It's not your job title that triggers the law, it's the specific services you provide.
Let's look at part 3, your new legal obligations.
Now that we know who's in the crosshairs, we have to talk about what you actually must do to stay operational and out of trouble. Let's look at the timeline. Pre-2026, you were largely unregulated in this specific context. Then, on March 31, 2026, AUSTRAC enrollment officially opened. But here's the really terrifying reality check. Today is late June 2026. That July 1st deadline, where obligations and penalties fully kick in, is literally just days away. The window to casually prepare is slammed shut. We are in the immediate action phase.
So, breaking down this massive operational burden, there are 4 core steps you've got to integrate into your workflow, like yesterday. First, enroll with AUSTRAC immediately. Second, assess the specific money laundering and terrorism financing risks within your own business. Where are your blind spots? Third, you have to implement a full AML and CTF program. This means doing mandatory customer due diligence. You have to verify identities, dig deep to find the ultimate beneficial owners of complex trusts, and prove the actual source of their funds. And yes, you have to do this even if clients get annoyed or push back. Finally, if something seems off, you are legally obligated to confidentially report it to AUSTRAC and keep meticulous records for at least 7 years.
Which naturally leads us to part 4, the multi-million-dollar fines.
I want to be really clear here. This is not a slap on the wrist. We are talking about severe financial consequences if you fail to meet these new obligations. Brace yourself for the sticker shock. If you operate as an individual and you get this wrong, you could face up to a $6.6 million civil penalty. Let that number just sink in for a second. The regulator is pricing in massive deterrence here. They want the penalty to utterly dwarf any profit you might make from turning a blind eye. A fine like this would instantly bankrupt a solo practitioner or a small partnership. No question.
And what if you're a body corporate? Well, that maximum civil penalty skyrockets to an unbelievable $33 million. Plus, there are criminal penalties for serious or systemic noncompliance. And the reason this is so absolutely crucial to understand is that these regulatory fines are largely uninsurable. You can't just buy a policy to bail your business out of ignoring the law. If Austrac drops a massive penalty on you, that cash is coming straight out of your bottom line.
All right, Part 5, the hidden insurance trap.
Now this is the real plot twist of this explainer. While everyone is panicking about Austrac, this enormous new data collection mandate is secretly creating a catastrophic vulnerability in a totally different part of your business. Over 100,000. That's the number of small businesses that will instantly lose their Privacy Act exemption on July 1st. Why? Because to satisfy these new AML rules, you absolutely have to collect highly sensitive client data, passports, driver's licenses, source of wealth records. Because you're holding that data, you are suddenly subject to the Australian privacy principles. You are now guarding a treasure trove of data that cybercriminals are actively hunting for.
And that right there creates two massive insurance gaps that most professional practices don't even realize they have. First up, professional indemnity. Your duties to your clients are expanding heavily under Tranche 2. If you bungle the customer due diligence or make an administrative error that costs a client a major transaction, you are at a severe risk for a professional liability claim. Second, cyber and privacy liability. Because you're hoarding all this sensitive ID data and you've lost your privacy exemption, a data breach means massive privacy liability. Standard off-the-shelf legacy policies won't automatically cover Austrac reviews or these new privacy claims. They have to be specifically updated for this new reality.
Finally, Part 6, the action plan. Let's talk survival.
So the crucial point is, understanding the risk is just step one. You have to take action right now to survive this July 1 rollout. Here is your immediate checklist. Enroll with AUStrack today. Do not wait. Jump on their website and use their tool to confirm exactly which of your services are designated. Start talking to your clients right now about these new ID requirements so they know it's a mandatory government law, not just you being difficult. Pick up the phone, call your insurance broker, and explicitly ask if your professional indemnity covers AML regulatory costs. And lastly, get robust cyber and privacy liability cover in place for all that sensitive data you're about to stockpile.
I really want to leave you with this final thought. July 1st is literally days away. Is your business genuinely ready to comply and stay protected? Or are you currently operating exposed to massive, uninsurable ruin? Seriously, don't wait until Austrac comes knocking to find out. Take action today, talk to a licensed professional or broker, and get your compliance and your coverage locked in before time runs out. Thanks for joining me on this explainer, and definitely stay protected out there.